Imagine a $1 trillion Wall Street fund trying to buy this, like, towering state-of-the-art skyscraper in Dubai.
Okay, quite the purchase.
Right. And the money is ready. The building is beautiful. But there's a catch.
There's always a catch.
Exactly. So the only proof of ownership for this billion-dollar piece of real estate is just a string of digital code.
Right, sitting on a decentralized server network.
Yeah, with nodes in, Iceland, Singapore, and Texas.
Right.
Now, if the market crashes or the seller tries to back out, who do you call?
That is the million-dollar question. Or, well, billion-dollar question.
Which court do you go to? For years, the terrifying answer for big traditional money was just nobody knows.
Yeah, nobody had a clue.
And that absolute lack of a safety net completely terrified institutional investors.
Yeah, for sure.
Keeping them miles and miles away from on-chain real estate.
It really was the ultimate standoff, You had the unstoppable force of blockchain innovation just colliding with the immovable object of centuries-old property law.
Right, because big money wants innovation, sure.
But above all else, big money demands certainty. I mean, when you are moving billions of dollars, you do not play guessing games with the jurisdiction.
You really don't. Welcome to the Deep Dive. Today, we are bringing you directly into the center of a massive paradigm shift in the global financial system.
A truly historic shift.
Yeah. We are unpacking a dense, but honestly completely groundbreaking set of notes and research centered around the Clarity Act and the future of on-chain real estate.
It's fascinating stuff.
It really is. And our mission for you today is simple but massive. We're going to unpack exactly how this ambiguous, highly speculative technology has just been transformed into a formalized, legitimate, global asset class.
From total Wild West to Wall Street standard.
Exactly. Okay, let's unpack this.
To really set the scene for you, we have to recognize the sheer magnitude of what is happening right now.
Right.
We are looking at the exact moment where cautious, traditional capital, sovereign wealth funds, massive pension funds, the biggest banks on the planet.
The real heavy hitters.
Exactly. Where they finally bridge the gap to the frontier of on-chain land titles. Because, for years, these two worlds were entirely incompatible.
Totally oil and water.
Yeah. We aren't just looking at a neat little software update today. We are looking at the exact blueprint that finally convinced Wall Street that buying a digital token representing physical dirt is actually a safe bet.
And to understand how we got to this solution, we first need to, thoroughly dissect the problem.
Right. The friction.
Yeah, because for a long time, there was this massive wall separating these two worlds. It was a severe friction.
A massive roadblock.
And what was causing that friction, it was a long-standing jurisdictional debate tied up in an era that we can confidently call the age of speculative tokenization.
And that phrase right there, speculative tokenization, that is the crux of the entire issue.
Let's break that down.
Yeah, let's look closely at why this friction existed for so long. I mean, imagine you were a compliance officer at a major pension fund.
Yeah, stressful job.
Highly stressful. Your entire job is to minimize risk. You are managing the retirement money of millions of people.
Right.
If you buy a traditional skyscraper, you get a thick stack of paper deeds, physical stamps from notaries.
The old school paper trail.
Exactly. And a local government office files away a hard copy in a metal cabinet. If something goes wrong, you know exactly which local judge in which specific city is going to hear your case.
Right. The rules of engagement are crystal clear. You have legal bedrock.
Exactly. But if you bought a digital token that supposedly represented that same physical piece of land, nobody actually knew which jurisdiction's laws applied.
Which is wild to think about.
It is, because if the physical land is in one country and the servers hosting the blockchain are scattered across the globe.
Like the Iceland, Singapore, Texas example?
Right. And the buyer is sitting in a corporate office in a third country. I mean, whose laws matter?
It is a jurisdictional nightmare.
A total nightmare.
If you were that compliance officer and your boss asks, hey, if the seller defaults, where do we file the lawsuit? And your answer is, well, maybe Dubai, maybe Texas, or maybe we just yell into the decentralized void.
Yeah, you are gonna get fired.
Immediately.
Which is exactly why, before now, on-chain real estate was viewed merely as a crypto hype project.
It was purely speculative.
Right. Without an answer to that jurisdictional question, the biggest pools of money on the planet just stayed on the sidelines. The fiction wasn't because the big banks didn't understand the technology.
Though they understood it perfectly well.
They did. The friction was a total lack of legal certainty. As long as the question of jurisdiction remained this this debate rather than a settled fact.
Right.
Any investment in on-chain land titles was an act of speculation rather than a sound institutional investment.
So let me ask you this, just to make sure we are pinning down the exact root of the problem here.
Sure.
Was this jurisdictional debate really the sole reason the space remained purely speculative until now?
It really was.
It's because we've heard promises about blockchain real estate for over a decade.
Yeah.
Was the technology actually ready and it was just the lawyers holding everything up?
Yes. Honestly, yes. The underlying technology to tokenize assets, to create immutable ledgers, has been robust for quite some time.
Okay.
But technology alone is insufficient to create a global asset class. I mean, a perfectly coded smart contract doesn't magically stop a local mayor from seizing a building.
Right. Code doesn't override police.
Exactly. Institutional capital was repelled by the legal ambiguity, not the cryptography.
Which brings us perfectly to the historical pivot point. Because if the core problem was a lack of clear rules across borders...
Everything changed in 2026.
Exactly. This is when the antidote arrived. The Clarity Act.
What's fascinating here is the precise function of this legislation.
Yeah, let's get into that.
The Clarity Act didn't just soften the legal ambiguities of 2026. It didn't just offer guidelines or, suggest best practices.
Right.
It eliminated them. This is the exact mechanism that bridged the friction we were just talking about. It established a universal set of compliance benchmarks that legally bind the digital token to the physical property in a way that multiple international jurisdictions officially recognize.
And this is where we need to look at the how. Because I want to push back on this utopian view of the Clarity Act for a second.
Fair enough. Push away.
Because if you're listening to this and thinking, I've heard the crypto hype before, why is 2026 any different? That is a very fair question.
Very fair.
The Act establishes compliance benchmarks. But wait, hold on. Even if a piece of legislation outlines benchmarks, physical dirt is still located in a physical country.
It is.
It is governed by local police and local judges. How does writing down a set of international compliance benchmarks in 2026 automatically silence a long-standing jurisdictional debate?
That's the core question.
Right. Does it force the technology to change to fit the law? Can a piece of international legislation just wave a magic wand over a local mayor and say, hey, this blockchain says Wall Street owns the building now, back off?
That is the multi-trillion-dollar question, and you are absolutely right to challenge it.
Because it sounds almost too good to be true.
It does. Because simply writing a law doesn't magically make the technology compliant. And it certainly doesn't magically erase local sovereignty.
Right.
A piece of paper cannot force a blockchain to do anything, nor can it stop a local police force.
Exactly.
The law simply sets the target. It creates the legal framework. But the technology has to prove it can actually hit that target and execute within that framework.
Okay, so it's a two-part harmony.
Exactly. And that is exactly how we move from legal theory to the practical reality of how this actually works.
And that leads us right into the engine room of this whole operation. Because the breakthrough wasn't just the Clarity Act itself.
Right, it was the application.
It was the specific technological application that proved it could handle the Act's requirements. We are talking about HBAR-based smart contracts.
Yes, crucial piece of the puzzle.
Now, for anyone who might not be deep in the technical weeds, let's clarify what HBAR is. We aren't just talking about a generic crypto network here.
No, not at all.
We are talking about the Hedera network, right?
Correct. Hedera, or HBAR, operates a bit differently than something like Ethereum. It uses a hashgraph consensus algorithm, which is highly suited for enterprise applications.
And why is that important for Wall Street?
Well, when you are a traditional bank moving massive amounts of capital, you cannot deal with network congestion or unpredictable, skyrocketing transaction fees.
You can't have a gas fee suddenly spike to thousands of dollars.
Exactly. You need high throughput, absolute finality in seconds, and fixed, predictable costs.
Wall Street hates unpredictable fees almost as much as they hate legal ambiguity.
They despise both. But, more importantly for our discussion, Hedera's architecture allows for incredibly complex conditional smart contracts that can integrate directly with external real-world data securely. And that is the secret sauce here.
Here's where it gets really interesting. Think about an analogy.
Let's hear it.
Let's go back to our billion-dollar skyscraper. If the Clarity Act is a brand new, incredibly rigorous international building code,
Okay, I'm with you.
You cannot just assume a building is safe to live in simply because the code was published.
No, definitely not.
You have to actually test the structural materials to see if they meet the code.
And in this scenario, the HBA-based smart contracts are the structural steel.
Exactly. But let's push that analogy even further to explain exactly how this bypasses the local judge problem I brought up earlier.
Let's do it.
It is not just that this digital steel was stress tested. It is that the HBAR smart contract acts like a ruthless robotic building inspector that completely controls the money.
A robotic inspector with the checkbook. I like that.
Right. This robotic inspector refuses to release the funds from the buyer to the seller unless the structural steel mathematically proves it meets every single standard of the International Building Code.
That is a brilliant way to visualize it.
It really clicked for me when I read that.
Let's walk through the actual mechanism of a transaction post-Clarity Act to see how this robotic inspector works in practice.
Yeah, please do.
Because before 2026, you sent your money, you got a token, and you just sort of hoped the local jurisdiction recognized it.
Fingers crossed.
Exactly. Now, with the Clarity Act providing the legal mandate and HBAR providing the execution, the process is completely different.
Walk us through it step by step.
Let's say that Sovereign Wealth Fund wants to buy our Dubai skyscraper.
Okay, money is ready.
The funds are locked into an HBAR smart contract in escrow. The contract is coded with the specific compliance benchmarks demanded by the Clarity Act.
So the rules are baked in.
Right. Now, how does it deal with the local jurisdiction? Well, the smart contract requires multiple cryptographic signatures before it will execute.
Okay.
One of those signatures must come from a registered, legally recognized oracle, a secure data feed that verifies the local land registry has officially recorded the pending transfer according to local law.
Ah.
Yeah.
So the contract is actually talking to the local government systems before the money even moves.
Exactly. The local rules aren't being bypassed or ignored.
They're being integrated.
Yes, they are being absorbed into the mathematical requirements of the smart contract. The Clarity Act provided the legal framework that basically says, hey, if these specific benchmarks are met natively within the contract, all participating nations legally recognize the transfer.
Wow, that is huge.
So the smart contract checks the oracle, it verifies the local land registry has updated, it verifies the international compliance benchmarks are met.
All in real time.
All in real time. And only then, simultaneously, in a fraction of a second, the HBAR contract releases the funds to the seller and the tokenized land title to the buyer.
So to answer my own pushback from earlier.
Yeah, your local mayor problem.
Exactly. How does an HBR contract stop a local mayor from seizing the land or a local judge from intervening?
Right.
It stops them by ensuring the local laws were cryptographically satisfied and locked in before the transaction ever finalized.
Exactly. It's proactive, not reactive.
So if the local mayor tries to step in and stop the registry update, the oracle doesn't get the data, the compliance benchmark fails, the HBAR contract automatically reverts, and the Wall Street Fund gets its money back instantly.
Precisely. The contract itself is the compliance. By successfully running these specific HBAR contracts against the new benchmarks, it was definitively proven that the technology and the law have finally aligned.
They are speaking the same language.
Yes. The rules are no longer external to the asset, waiting to be interpreted by a local judge after a deal goes sour.
Right.
The rules are coded natively into the asset itself.
That completely eliminates the friction. Because if you are that compliance officer at the pension fund, you no longer have to worry about whose court you're going to end up in.
You don't end up in court at all.
Because the transaction mathematically cannot execute unless the legal bedrock is already secure.
Which is why the implementation of these compliance benchmarks on the Hedera network is the definitive end of the era of speculative tokenization.
It's just over.
It is. When the execution of the law is guaranteed by the code, speculative tokenization is officially dead. It has been transformed into a legitimate global asset class.
And that word global is doing a lot of heavy lifting there.
Oh, absolutely.
And I want to make sure you, the listener, really grasp why that matters. The data doesn't just call it a legitimate asset class. It specifically calls it a legitimate global asset class.
And it earns that title because it successfully silences the long-standing jurisdictional debate. Think about what that actually means.
It's massive.
It doesn't mean the debate was won by one specific country. It means the debate itself was made entirely obsolete.
Right. Just doesn't apply anymore.
Exactly. When you have a smart contract that natively executes compliance benchmarks that are universally recognized under the Clarity Act, Local jurisdictional infighting just loses its teeth.
Yeah.
The global standard supersedes and automatically verifies the local requirement.
This is such a massive shift in how humanity handles ownership.
It really is a historical milestone.
We are moving away from a reality where a vulnerable piece of paper in a local cabinet dictates your ownership of physical property.
Right, the old way.
We are stepping into a reality where an internationally recognized, cryptographically secure smart contract seamlessly binds institutional capital to on-chain land titles.
Seamlessly.
And it all hinged on eliminating those 2026 legal ambiguities.
Because without the technological capacity to actually meet the benchmarks of the Clarity Act, the legislation would just be empty words on a page.
A nice idea, but useless.
Exactly. And conversely, without the Clarity Act providing the legal definitions, the most advanced HBAR smart contract in the world would just be a speculative toy.
Right, it goes both ways.
It does. But by proving that the technology can effortlessly bear the weight of the regulation, the door to this new asset class has been kicked wide open.
Wall Street finally has its safety net.
They finally do.
Let's bring all of this together and synthesize the journey we just took you on today.
Let's do it.
We started by staring down a massive wall of friction.
Yes, the big divide.
On one side, you had trillions of dollars of traditional institutional capital looking for yield. On the other side, you had the incredible efficiency of on-chain land titles.
But they were kept completely apart.
Kept apart by the terrifying Wild West of speculative tokenization and this endless, unresolved debate over which country's laws actually mattered.
Then we saw how the landscape radically shifted in 2026.
The game changer.
The Clarity Act arrived, harmonizing international law and completely wiping out the legal ambiguities that were keeping big money at bay.
Right.
It established rigorous compliance benchmarks.
But the law was only half the battle.
True.
We then explored the mechanism. We learned how specific HBAR-based smart contracts, acting like our robotic building inspectors, were put to the test.
And they passed with flying colors.
They did. They proved that they could natively execute those new compliance benchmarks, communicating directly with local registries to ensure a legal bedrock was established before a single cent moved.
Incredible technology.
And by doing so, they officially proved that regulatory certainty has legitimized a global asset class. So what does this all mean for you?
It means that you are currently living through a fundamental rewriting of global finance.
Yeah, it's not an exaggeration.
It isn't. The way the world defines, records, and invests in physical property has crossed a point of no return.
A total paradigm shift.
You are witnessing the birth of a formalized global asset class. For the first time in history, the massive, risk-averse engines of traditional finance have a clear, legally sound, and technologically proven pathway to interact with on-chain real estate.
The days of ambiguity are over.
They are completely over. The era of institutional on-chain ownership has truly begun.
And that leaves us with one incredibly massive implication to ponder.
Oh, yeah.
Because real estate is just the beginning.
It's just the tip of the iceberg.
If the Clarity Act and these highly advanced compliance benchmarks successfully silenced a jurisdictional debate for something as historically complex, local, and paper-heavy as physical dirt.
Right, which is arguably the hardest asset to modernize.
Exactly. Then what happens next? What other massive old-world asset classes are about to be suddenly and violently pulled onto the blockchain now that the exact blueprint for regulatory certainty has been proven?
That is the million-dollar question right there.
Are we looking at the tokenization of global intellectual property?
Very likely.
Commodities. Fine art. The bridge has been built, the fog is cleared, and the capital is waiting. Keep an eye on what crosses over next.